Hi, welcome to LonghausTV. You're on the Research Channel. I'm Scott Stewart, and with me today we have Bill Singleton, who's a practicing partner at Hines Lawyer, and Bill works in the IP IT law space. Welcome, Bill.
Thanks, Scott.
Bill, we want to talk about the Privacy Act. So we are hearing that there's revisions currently out there and some big changes happening, particularly with the introduction of directors' liability, customer consent, all sorts of issues. It sounds like a bit of a minefield, and with the cloud computing happening, all the discussion about onshore, on-premise data, perhaps you could talk us through what you're seeing is happening in this space.
Okay, Scott. One of the biggest risks seen in any type of cloud outsourcing type contract is the privacy risk. So typically an organisation may collect personal information about its customers or its suppliers, and that information may be hosted offshore. So we're talking about offshoring data. So currently the Commonwealth Privacy Act, the Australian Commonwealth Privacy Act, covers how that organisation collects, stores and uses that information. So as you pointed out, that Privacy Act has been revised, and we have some changes which we think will probably come in this year. So there's been a change about fundamentally who is responsible for that personal information when it's sent overseas, and it really boils down to the organisation that sends it overseas. The company that collects it and sends it overseas will be responsible for that. For the privacy of that personal information. So now if you extract that to the company itself and where the liability lies, generally the liability for the actions of a company lie with its officers and its directors, and then we have the question of what are the obligations on the directors in terms of what due diligence they need to do before they allow that data to be sent overseas.
So let's bring it down to a practical example. So Salesforce is an example, offshore customer data. So if there's a privacy breach or intrusion, whatever, who ultimately is responsible, and what can the CIO do to protect against that scenario?
Okay, so if, for example, there's a data breach and there's a loss of personal information overseas, if there's a sufficient loss to somebody and they decide that they want to take some action under the Australian Privacy Act, they will then make a complaint to the Australian Information Commissioner, who will then look at how that personal information was collected and whether the Privacy Act has been complied with. So included in that will be whether the company and through the company, the directors had done sufficient due diligence to ensure that that information would be held securely, that would be treated in compliance with the Australian Privacy Act, and what they actually did before they sent that data overseas. So from a CIO's perspective, of course, he has to ensure that before that data is sent overseas, that he's made a reasonable attempt to comply with the obligations the company has under the Australian Privacy Act. So that would include, for example, making a reasonable attempt to find out where the data is going to be stored, the security with which the data would be stored with, and what will happen to that data, whether it will be disclosed to anybody and how it will be used. If that hasn't happened, then there's a potential breach of the Australian Privacy Act.
So a lot of the vendors are saying that there aren't any laws currently that are stopping companies from sending their data overseas, but this is definitely a minefield.
Well, I wouldn't say there's no laws. There's not a law that stops it. There isn't a law that says, for example, you must not send data overseas.
That's right.
Rather, it says, if you send data overseas, these are your responsibilities in relation to that data. It's called the long arm of the law. It actually extends to the country where you are sending that data. I should mention that there are provisions within the Act which say basically that if you're sending, or you're able to send personal information to countries that have a comparable privacy regime to Australia, the question of course is which of other countries have a comparable privacy regime to Australia, and that's actually quite a difficult question to answer.
And it also gets down to the states, doesn't it? So last year we had the Victorian Privacy Commissioner come out and say, well, they're going to protect the rights and privacy of Victorian citizens. So does it mean that not only do these vendors, one of those checklists was, is the vendor, the service provider, complying with the privacy provision? So that means for each state of, where the data resides, where the person whose data it is, where they're residing.
Yes, correct. The way that it works is that the Commonwealth or federal legislation is meant to cover the field, so it covers the whole of Australia. That doesn't mean, for example, though, that Victoria or Queensland or New South Wales can't enact its own specific privacy legislation, and where that's different to the Commonwealth legislation, both of them potentially can apply. So the answer to your question is, unfortunately, yes, you need to look at both Commonwealth and state legislation in terms of privacy, not only in terms of where you're collecting it, but where you're storing it, because, I mean, as you understand, when you're storing data, even within Australia, there's no sort of guarantee, particularly which state it can be in. It can be in sort of more than one state.
Yeah, is there a vendor out there that would sign a guarantee to say, we'll comply with all the Australian privacy provisions, and how much strength would such a guarantee have?
Well, going back to the question that you posed earlier, it's not so much the vendor that will be where the liability lies, it's with the company. So the vendor's obligation really is to not do anything which would assist or help anybody to breach the Privacy Act. So in other words, if you've got very lax security in your application and it's fairly obvious that you're likely to lose personal information, shall we say, that's the sort of area that you would want to pin the vendor down on, to say that you're using reasonable security measures in the construction and operation of your software.
But isn't it a case then, and then isn't that a further minefield in relation to some of the infrastructure as a service providers have perimeter security, they have all sorts of intrusion protection services, but they don't look after the application. So whether it's an application vulnerability or an infrastructure vulnerability, it sounds like it's just very difficult for the CIO to really do enough, to really protect the enterprise.
Yes. So really, again, that's a very good question, and really what it boils down to is that the actual Act says that you have to use a reasonable amount of security. So when that comes back to the obligation on the CIO has to do what's reasonable. So it's reasonable due diligence. So if it's, for example, a medical system where you have personal information plus medical information, then there would be a very strong onus on the CIO to ensure that the systems are secure, there's perimeter security, there's intrusion detection, there's web penetration testing, all of those things, all of the established categories of IT security and all the international standards you would want to make sure that they are applied and they're contractually obligated to supply. On the other hand, if it's data that isn't so critical, then the due diligence requirement on the CIO would possibly be less. So the CIO only has to do what is reasonable in the circumstances.
But it sounds like what you were saying there earlier is that now the contracts now have to detail what is reasonable security and all the standards that are required. So again, we're getting back to the fact that we're a long way from getting to a sort of a mature, good place in relation to having all that stuff nailed.
Well, it depends depends where you go and what detail you want to go into. So, for example, if we have a client, which we sometimes do, that has a very critical application, they will want all of that kind of detail put into the contract. So it would say, for example, reasonable security, including penetration testing, all the different types of categories. Then you can show that it's reasonably been done. It depends on the risk.
And we've had a lot of privacy breaches, and there's been a lot in the news,
Yes.
some big names. So it's really about the reporting of those breaches, isn't it? And that's
Yes. That's a very good point as well, Scott. In terms of the damage, is really reputational damage.
It is.
The monetary damage is generally very low, and particularly now under the current Privacy Act, the penalties aren't particularly stringent. That may be changing when the Act changes, but currently they're not that stringent. But it's reputational damage. So if you look at some of the high-profile Vodafone, Telstra issues, that's where the damage occurs.
So, Bill, what's the best advice at the moment?
Well, the best advice at the moment is to look at the risk you're facing, and your response is proportionate. So that would include whatever's reasonable in the circumstances.
And criticality of the data sounds like that's the real issue, and potentially that's has to go a long way before we're prepared to move critical data into cloud.
Correct. So just a quick example: the username, password, and credit card number, that would be critical data. You would want to ensure that all reasonable standards are being applied in relation to that. Once you've done that, you can sleep at night knowing that you've done pretty much what you need to do to secure that data.
So, Bill, in the revisions to the Act, they do talk about obtaining customer consent, and I was sort of wondering whether that was actually a viable option, is to basically go to your customers and get the consent for us to put your data offshore. Is that likely to happen?
Consent is available and pretty much cures everything in privacy law. So if you consent to your personal information being sent overseas, then that is a good defence against any allegation that you're breaching your privacy obligations. However, whether it's practical or not is another matter. So if you've got like a few 100,000 clients, you have to get individual consent from each one of those. That's not likely to be practicable. What is practicable is gaining that consent at the time that you collect that information. And again, that comes down to the advice you get and how you draft your collection statement in terms of when the end user is giving you that personal information.
Is that likely to be that splash screen with all the small print that we just go?
That's the one that you go zhit and click yes.
Agree. So there's a cheaper, easy way out for some enterprises to use that.
Yes, but you've got to get it at the right time. If you've got it ideally at the point of collection rather than post-collection. That's when it becomes difficult.
And again, we're talking really about the application layer, not so much a cloud provider providing infrastructure.
Absolutely.
So again, it could be a multi-vendor arrangement for the CIO to sort of cover all the bases.
Correct. Yes. So if, a CIO should really be looking at, number one, the criticality of the data. Number two, what privacy consents I need. Number three, which model am I going to use on-premise cloud? It's all part of the due diligence which you should be doing at the beginning.
I certainly know that from my own experience that with our cloud strategy where I was previously as a CIO, we spent a number of months on the financial models and the business case, but I think the whole legal, the contractual drafting was a good 4 or 5 month exercise, and we had to start from scratch. So clearly, there's still some really big considerations for the CIO in adopting cloud and even just privacy in general.
Yes, that's right. And the maturity model, as we've been discussing, is emerging, shall we say.
So a lot of the vendors are saying that they have stronger, better security than a lot of on-premise, and I'm sure in a lot of cases that is true. So is there a risk that the CIO will kind of retract into building a private cloud or retaining a lot of that on-premise? So doesn't the same risk stand there? I mean,
I think it's a very good point that you make in terms of it is likely that a major vendor will have better security than an on-premise situation. However, that doesn't take the onus off the CIO to do proper due diligence to establish that. So if for example, if a large vendor says we have all the best security or reasonable security, you'd want them to prove that to you.
So again, here's some competitive differentiation for a vendor to have basically all that on display in a sense to give the CIO some confidence.
Within a contract.
Within the contract, of course. Thanks, Bill. Thanks for your time.
Thank you.
Hi, welcome to LonghausTV. You're on the Research Channel. I'm Scott Stewart, and with me today we have Bill Singleton, who's a practicing partner at Hines Lawyer, and Bill works in the IP IT law space. Welcome, Bill.
Thanks, Scott.
Bill, we want to talk about the Privacy Act.
Privacy risks. So typically, an organisation may collect personal information about its customers or its suppliers, and that information may be hosted offshore. So we're talking about offshoring data. So currently, the Commonwealth Privacy Act, the Australian Commonwealth Privacy Act, covers how that organisation collects, stores and uses that information. So as you pointed out, that Privacy Act has been revised, and we have some changes which we think will for the actions of a company lie with its officers and its directors. And then we have the question of what are the obligations on the directors in terms of what due diligence they need to do before they allow that data to be sent overseas.
So let's bring it down to a practical example. So Salesforce is an example, offshore customer data. So if there's a privacy breach or intrusion, whatever, who ultimately is responsible, and what can the CIO do?
Will probably come in this year. So there's been a change about fundamentally who is responsible for that personal information when it's sent overseas. And it really boils down to the organisation that sends it overseas. The company that collects it and sends it overseas will be responsible for that, for the privacy of that personal information. So now if you extract that to the company itself and where the liability lies. Generally, the liability...
Hearing that there's revisions currently out there and some big changes happening, particularly with the introduction of directors' liability, customer consent, all sorts of issues. It sounds like a bit of a minefield, and with the cloud computing happening, all the discussion about onshore, on-premise data, perhaps you could talk us through what you're seeing is happening in this space.
Okay, Scott. One of the biggest risks seen in any type of cloud outsourcing type contract is